My name is Mike Colombo. I'm a partner with the Dhillon Law Group, and I have the honor of representing the plaintiffs in a lawsuit that we have just filed. We have filed this lawsuit because the map enacted in Proposition 50 for California's congressional districts is unconstitutional. The map is designed to favor one race of California voters over others. This violates the 14th Amendment's guarantee of equal protection under the law and the right under the 15th Amendment to not have one's vote abridged on account of race. When drawing the Proposition 50 map, the chief consultant who drew the map has stated that the first thing that he did was to increase the power of Latino voters. Additionally, the state legislature has announced that the maps increase the power of Latino voters. Okay, I want these 5 stations to come up here. Kidding. All right. Let's tighten that up. There you go. Okay.
Tension might be on the other dial.
All right. So I'm talking to AP, ABC, Fox 40, KTLA, and KCRA. No more interviews. All right, so the Prop 50 maps accordingly increased the number of districts in which Latinos are favored to win the election or win their preference in the election from 14 to 16 of California's 52 congressional districts. When states racially gerrymander their voting districts, the Supreme Court has permitted a limited exception to the Constitution. That exception requires, among other things, that the favored voters are a minority whose preferred candidates cannot get elected because of the votes of another majority race. Due to California's marvelous diversity, of which we are all proud, Hispanics make up the most voters in the state. There is no majority race in California more than Hispanics. Hispanics have had fantastic success in electing candidates of their choice. Accordingly, California cannot meet this exception. The exception also requires not that we come up with some kind of after-the-fact rationalization for the maps, but that in fact the legislature considered the evidence and the analysis that required racial gerrymandering to avoid violating people's civil rights. The record we have establishes that before the maps were voted upon and after, analyses were conducted that concluded that there was no voting rights problem in California's prior maps for the legislature to remedy. Further, there is no evidence whatsoever that the California legislature in fact circulated any such analysis to the legislatures for them to consider when they cast their votes to launch Proposition 50. Accordingly, California cannot satisfy the Supreme Court's exception, and Proposition 50 will be found unconstitutional. I'm turning over to David Tengipa, one of the plaintiffs, who would address you next.
Good morning, everyone. I'm Assemblyman David Tengipa, and as an elected official here in the state of California, I'm appalled by what has happened, with what the legislature really pushed through, with what the governor has done to violate and break the Constitution. And when I said that the fight for California has just begun, I hope everybody and anybody knows I meant that. As the first Polynesian elected ever to the state legislature, I understand the diversity and the beauty that this state has. And what we have seen with Prop 50, these maps, they are completely diminishing the voices of other groups to benefit other groups. They have weaponized this entire process, and they have lied to the California voters. They have lied to the people of California, and what this is about is holding those individuals accountable. What this is about is fighting for our voices to make sure that we are all heard, the same as everybody else. We have watched this entire process from the very beginning. In the Elections Committee, nothing was given to us to define why they are doing this. Nothing was given to us to make sure that they were following the Constitution. Nothing. Lies after lies after lies. You can go back and listen to them yourself. The other members stated that they voted on this without even reading it. How can they say they were protecting our voices? The chair of the Elections Committee didn't even know that the maps had changed while we were voting on them. How can they say they were protecting our voices? This whole process was a sham. And with this lawsuit, we will make sure that we will expose it and we will hold those accountable. That is what this is about. Thank you.
And now a word from Corinne Rankin, the chair of the California Republican Party.
Thank you. Good morning, everyone. My name is Corinne Rankin. I'm the chair of the California Republican Party. And on behalf of the California Republican Party and its board of directors, we're proud to have signed on to this lawsuit. We have a very diverse board of directors at the party. And, for us, this is one about the Constitution. It's about the rights that our ancestors have fought so hard for in this country. It's about sticking with the Constitution, and it's about equality and fair and equal treatment. And we believe that Californians, no matter what color your skin is, no matter what your socioeconomic background is, you deserve to be treated fair. You deserve to be treated equally. And that's what this lawsuit's about. Fair and equal representation for every Californian, no matter the color of your skin. Thank you.
And my colleague Mark Moiser, who's a key member of the team who prepared this lawsuit.
Mark Moiser here, attorney with the Dhillon Law Group. The 14th and 15th Amendment of the United States Constitution was designed to create a colorblind society. Because of the racism in this country, from the 1860s through the 1960s, Congress felt that they needed to remedy that, and they did so with the Voting Rights Act. And the Supreme Court has been very clear. If you are going to draw what are called Voting Rights Act districts, VRA districts, if you're going to do that, there is a three-part test that you must fulfill before you draw those districts. It is abundantly clear by the testimony of the legislature and the testimony of Paul Mitchell that they drew 16 VRA districts in California. The Supreme Court has said that before you draw that, the legislature needs to ensure that there is a problem of racism, that there's a problem that the majority is preventing the minority from being elected, and that because of this problem, they're going to remedy it with the lines that they are in fact drawing. As you heard from Assemblyman, they never received that analysis. The legislature never debated or discussed whether there was a past problem, whether they met the Jingles three-part test. And the third test of Jingles, this test laid out by the Supreme Court, is that a white majority, and that majority means more than 50%, a white majority voting as a block prevents a minority from voting in almost all circumstances. California has probably the most diverse statewide elected officials. You look at our congressional delegation, look at the Assembly, look at the Senate. Because of our diversity of population, we have a diversity of politicians. There is no white majority in California. There is no white plurality in California. The leading demographic is the Hispanic community. And we expect the evidence will show that the voting patterns in California will show that Californians vote on party lines, not based upon the color of your skin. We believe that the Supreme Court jingles test cannot be satisfied by the state. As such, under the 14th and 15th Amendment, the maps drawn by Prop 50 will be considered unconstitutional, and we are asking a federal 3-judge panel to find Prop 50 maps unconstitutional and go back to the commission maps. We will take your questions now.
Maya Miller from Cal Matters. How does this legal challenge fit in with the potential for the Supreme Court to make drastic changes to the Voting Rights Act? It sounds like you are making a similar argument to what the plaintiffs in that case are making.
Well, I think the question in that case is really about the exception, right? It's really about whether the Voting Rights Act can provide an exception to the Constitution in the way that it's being used. Our lawsuit is not challenging the current legal framework. We're saying that under the current legal framework, the maps are unconstitutional.
Do you want the current legal framework to stand?
It's not part of our lawsuit. If the legal framework does change, it will change our lawsuit. But our lawsuit that we filed today is within the existing framework that we have.
Can I clarify on the statistics that you're using? What statistics are you using to determine the ethnic and racial minority groups in California? Like, are you using census data, American Community Surveys, projections? Like, what are you using for that?
Our experts are using all of them. They're using the state's database where they've used Hispanic surnames. We are using the census data and then the yearly census data. So all of that is being considered in this.
I'm just confused because there's an option to be Hispanic, not white, and white, not white, Hispanic, and white, not Hispanic. So I don't understand how you're saying that the majority of Californians are Hispanic, but not necessarily, like, it's not mutually exclusive.
We're not saying that we're saying the plurality. According to the census, according to legal, the CVAP numbers, there is no majority. There's no white majority. There's no Hispanic majority. We have pluralities. And so regardless of the test that you use, there is no majority of any race in the state of California.
And just to clarify, when the lawsuit, if the court agrees that we've established that the lines have been drawn based on race, which we think the statements conclusively show, the burden will shift to the state to prove that it met that exception.
So what are the...
Just to follow up on that, are you talking about Hispanic voters or Latino voters then? Or are you using the two terms interchangeably here?
The demographic data uses the word Hispanic. So that is the word that, in terms of a legal discussion, we have to stick with that because that's where the data is. The political rhetoric that you've heard from the legislature uses the word Latino, but the data is the word Hispanic. That's why we're using that term.
So how does this actually play out? If the judges say this thing's unconstitutional, we just end up with the maps that we already have on the election, and what are we looking at in terms of timing on all of this?
So we're asking for an injunction. So over the next couple weeks, the 3-judge panel will hear evidence of whether they're going to enter an injunction to prevent the Prop 50 maps from going into effect. We anticipate that whoever loses that argument will be able to go to the Supreme Court, and we anticipate that that decision will probably need to be made before December 19th when candidates can pull papers for signatures in lieu. So over the next 6 weeks, the question before the courts will be which maps are the voters going to be voting on in 2026. After the initial TRO, preliminary injunction phase is over, we'll move into the discovery, depositions, and all that, and we would anticipate sometime next year actually hearing the merits of this matter.
So if this does get appealed to the Supreme Court, do you think at that point it would then intersect with the Louisiana case? Or how much does this lawsuit today hinge on that Louisiana case that's before the Supreme Court?
Again, the Louisiana court, or the Louisiana versus Calais decision is about, if you read what the Supreme Court asked in their brief, whether the Voting Rights Act itself is constitutional. Our case is under the current Supreme Court precedents that is in effect as of the date that the legislature adopted and the people of California adopted Prop 50. As of the date that that happened, under the test set forth by the Supreme Court, the state of California has failed that test, and these maps are unconstitutional under the current maps. If the VRA is deemed unconstitutional, then our case still is able to proceed because the state of California would have violated under the old test or the new test. But based upon what is the law of the land today, Calais will have little impact on what we have argued.
And then also the Citizens Commission that made the prior maps, they also considered race in drawing their districts. They drew Voting Rights Act districts. So why does the passage of Prop 50 have any bearing? Why wouldn't you have sued 4 years ago when they made those maps that did take race into consideration, just like these maps did?
Well, I can give you a very clear example of that. I represent a non-VRA district, and because of these maps, I now live in a VRA district. How can that justification make sense? How can that justification make sense? They have moved the lines where I now live in a congressional VRA district, but I represent a non-VRA district. That has changed the entire process to where there was no justification. We have been able to watch what the Citizens Redistricting Commission in committee was doing the entire time, but in 4 days, they did not do any of that. There was no legal justification to it, and that is why we are challenging these maps, because it doesn't make sense, because individuals like myself who represent a different district now live in a VRA district. That is what these maps have done. That's what's been forced. It has diminished the voices of a lot of people across the state of California, and we're going to push back on that.
And just to be clear, we're challenging what the legislature did a couple of months ago. If they violated the Constitution, they violated the Constitution. If they didn't, they didn't. Whether or not the commission did or not 4 years ago is not part of our case.
I think what Laura
And the
was
maps have
asking-
changed.
But yeah, how is what the drawing of these maps in taking race into consideration, how is that more problematic than the way the prior maps were drawn, which also took race into consideration? What's the difference? Why is there a lawsuit now, but there wasn't a lawsuit then?
Well, those are different questions, but look, I'm not challenging what the commission did. I'm not examining everything the commission did, so I don't know if the commission did it right or not.
Can I ask, are you objecting to the fact that these maps were drawn so quickly that there was not enough time to do any sort of justification, that there was an issue with a majority or a certain group overpowering another ethnic group's vote?
It's exactly the opposite. They did the analysis, and the analysis concluded that there was no problem, and they still drew the maps. And there's actually a second analysis that was done after the maps was drawn that concluded the same thing. There was no VRA, there was no voting rights problem before they drew the maps. There was no problem to remedy by these maps. These maps did additionally racially gerrymander and increase one race's voting power over others. That's the problem.
So you're from the Dhillon Law Firm. Obviously, the founder of the Dhillon Law Firm is now the Assistant Attorney General looking at civil rights issues. Is there a role for the Justice Department? Is there a role for the Civil Rights Department in this?
That's possible under the law, but I don't know what they're going to do.
Who was funding the lawsuit?
Go ahead.
The National Republican Central Committee NRCC has been funding this.
Congressional Committee.
Sorry.
Congressional.
National Republican Congressional Committee.